Welcome to Globalpose News. Donald Trump's push to end birthright citizenship is being argued at the U.S. Supreme Court, in a case that could help further his agenda on immigration and other issues. The court is hearing arguments on Thursday about whether lower court judges can block presidential orders for the entire country. Trump moved to end birthright citizenship within hours of returning to the White House in January, signing an order that said children who were born in the U.S. to undocumented immigrants would not be citizens. 3 federal judges stopped it from taking effect, part of a pattern of courts blocking Trump's executive orders. Trump contends they did not have the power to issue the nationwide injunctions. If the Supreme Court agrees with Trump, then he could continue his wide use of executive orders to make good on campaign promises without having to wait for congressional approval, with limited checks by the courts. It is unusual for the Supreme Court to hold a hearing in May, and there is no indication of when it may rule. Trump appointed 3 of the 9 justices on the conservative majority court in his first term. Many legal experts say the president does not have the power to end birthright citizenship because it is guaranteed by the 14th Amendment of the U.S. Constitution. So, even if Trump wins the current case, he may still have to fight off other legal challenges. Specifically, the 14th Amendment stipulates that all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens. In the executive order, Trump argued that the phrase jurisdiction thereof meant that automatic citizenship did not apply to the children of undocumented immigrants, or people in the country temporarily. Federal justices in Maryland, Massachusetts and Washington, however, issued nationwide, or universal, injunctions that blocked the order from being enforced. The injunctions, in turn, prompted the Trump administration to argue that the lower courts exceeded their powers. Universal injunctions have reached epidemic proportions since the start of the current administration, the government said in a March court filing. Members of this court have long recognized the need to settle the lawfulness of universal injunctions. Earlier this week, a Justice Department official told reporters that court injunctions fundamentally thwart Trump's ability to carry out his policy agenda, and that the administration sees this as a direct attack on the presidency. The case being heard in the Supreme Court stems from 3 separate lawsuits, both from immigration advocates and 22 U.S. states. The Trump administration has asked the court to rule that the injunctions can only apply to those immigrants named in the case or to the plaintiff states, which would allow the government to at least partly carry out Trump's order even as legal battles continue. Nearly 40 different court injunctions have been filed since the beginning of the second Trump administration, according to the Justice Department. In a separate case, 2 lower courts blocked the Trump administration from enforcing a military transgender ban, although the Supreme Court eventually intervened and allowed the policy to be enforced. An end, even a partial one, of birthright citizenship could impact tens of thousands of children in the U.S., with one of the lawsuits arguing that it would impose second-class status on a generation of people who were born and have only lived in the U.S. Alex Quick, an immigration lawyer and professor at Case Western Reserve University in Ohio, told the BBC that a potential end of birthright citizenship could force some of these children to become undocumented or even stateless. There's no guarantee that the countries where their parents are from would take them back, he said. It would not even be clear where the government could deport them to. For more updates, news, views from around the globe, follow us on all our social media platforms at Globalpose.